Um, Welcome everyone to the 112th informal discussion group session with Dr. Bibek Debroy, who is currently serving as the chairman of the Prime Minister's Economic Advisory Council. Our topic for today's session is the project on the repeal of archaic and absurd laws in India. And who better to address us on this session than Dr. Bibek Debroy, who has been at the forefront of this project and has been leading it. And as a matter of fact, as law students, we all know that the parliament in the last 5-6 years has repealed nearly more than 1,800 legislations which have turned obsolete. And therefore, we are indeed honored to have with us Dr. Bibek Debroy to address us on this topic. Before we begin, I would like to call Aditi Chande, who is the convener of the informal discussion group, to give a brief introduction of the guest.
Thank you so much, Anirudh. Good afternoon, sir. Today, we are honored with the kind presence of one of the illuminating minds of our country, Mr. Bibek Debroy ji, a repository of knowledge and wisdom in himself and an embodiment of humility and grit. Sir, I ran out of words when it comes to introducing you, given your countless contributions to the society at large. But to mention a few, Sir is the chairman of Prime Minister's Economic Advisory Council and has been a member of Niti Aayog from 2015 to 2019. He was also a visiting honorary senior research fellow at the Institute of South Asian Studies in National University of Singapore. He has made significant contributions to game theory, economic theory, poverty law reforms, railway reforms, and Indology, among others. In addition to being a former member of a National Manufacturing Competitive Council, Sir had translated the unabridged version of Mahabharat into English, becoming only the third person to achieve the feat. He has authored and edited over 110 books, papers, and articles. Sir was awarded Padma Shri in 2015 and Sri Ram Salam Award for Financial Journalism in 2013. He was also awarded a Lifetime Achievement Award by Prestige Institute of Management and Research in 2018. Once again, thank you so much, sir, for agreeing to have a session with us today. Over to you, Anirudh. Thank you so much, sir.
Thank you, Aditi. Sir, we can start.
Thank you, and thank you for inviting me. I think this has been pending for a very, very long time. At least I vaguely recall that you'd invited me several months ago. And I'm delighted to be speaking to you today. Unfortunately, because of the pandemic which is still amidst us, we have to do this virtually. What I propose to do is to speak for about half an hour, and then I'm happy to answer whatever questions you might have. I may not always have the answers to the questions that you're going to ask, but nonetheless. Specifically, I was asked to talk about the repeal of old laws. That sounds very exciting, and because I was asked to talk about that, I will focus on that. But before that, let me begin with a story. It's not a story, it's an anecdote. And in some sense, it illustrates the way law reforms happen in India, of which repealing old laws is only a thin slice. The anecdote that I'm about to relate goes back to the early 90s. 1993, in fact. In 1993, there was a famous economist whom I shall not name because he died. 1993, remember, was just about 2 years after the 1991 reforms. And everyone who's listening in and watching knows that in 1991, there was significant reforms, economic reforms in India, 30 years of those reforms have warranted some commentary in the newspapers and media. Anyway, 1991, the reform started, and we are at 1993. So there was this professor of economics who was going on a visit, a UGC-sponsored visit for a conference in Paris. And the per diem at that time allowed by the UGC was 65 US dollars a day. Per diem, for those who do not know, means the amount of money that you're allowed to take to pay for your board and lodging and incidental expenses. Economists, or at least famous economists, are a tight-knit community. So this particular gentleman, who was a professor of economics, as I just said, wrote a letter to the then finance minister, Dr. Manmohan Singh, who, as you know, is also an economist. And he said, 65 US dollars is too little. Can't you increase it? So the finance minister asked a question: who sets this ceiling and under what law? And a file started within government. It so transpired that this particular ceiling of 65 US dollars was under rules set up under the then Foreign Exchange Regulation Act. For those of you who do not know, there was a Foreign Exchange Regulation Act, FERA, of 1973, which was a tightening up of the original Foreign Exchange Regulation Act, which had been passed in 1947. So anyway, this was by virtue of one of the rules under one of the sections of FERA. So the file went up and down, and the question was legitimately asked: why should we suddenly relax the ceiling for one arbitrary individual? Shouldn't we actually ask, shouldn't the ceiling be removed for everyone? Shouldn't we actually ask whether that particular section of FERA was relevant or not? Shouldn't we actually ask whether FERA at all was relevant or not? And shouldn't we therefore finally ask whether there were many other pieces of legislation that needed to be taken a relook at? So as a result of that chance trigger, this project was set up, and this project was known as LARGE. LARGE stood for Legal Adjustments and Reforms for Globalizing the Economy. I headed that project, and when I was asked to suggest names for the project, one of the names I suggested, not my favorite one, was LARGE, and unfortunately that got to be accepted, so the project was known as LARGE. And what you may not know is that while I was the director of that project known as LARGE, which looked at reform of laws, I was a visiting professor at the National Law School, Bangalore, and I worked closely with Professor Madhav Menon, who was instrumental in setting up your particular institution. Legal adjustments and reforms for globalizing the economy, legal reforms. It was like a black hole. It means a whole lot of different things. One thin slice of that is the slice that I mentioned of repealing old laws, and I will come back to that. But I want to quickly mention that there are other aspects also. The legal system should have been reformed independent of the economic reforms. Economists talk about markets. Markets don't function in isolation. Markets are not agricultural mandis. Markets are conceptual structures used by economists And that conceptual structure, the basic framework for everything that exists in India today is the Constitution. And the legal system provides that infrastructural support for all the policies. And if the legal system does not deliver and deliver efficiently, no reforms are going to be credible. By the legal system delivering efficiently, one means that the honest are protected and the guilty are punished. No legal system is going to be efficient if we have almost 40 million cases stuck in Indian courts, without including the cases that are stuck in tribunals. So therefore, there are issues about speeding up the delivery of justice, punishing the mala fide and protecting the bona fide. There are issues with the procedural law, the Civil Procedure Code, the Criminal Procedure Code, the Indian Evidence Act, all of that. And while I'm supposed to speak on repealing old laws, let us not forget that that remains a very important part of the agenda. The second element of law reform that is important is unifying and harmonizing. Laws are enacted by parliament or by state assemblies at different points in time. If they are enacted at different points in time, definitions will be different. Notions will be different. The case law will be different. So one needs to rationalize and harmonize. And that can be a very important component of law reform. In fact, the most complicated part of law reform is rationalizing and harmonizing. A third element of law reform concerns the definition of the word law. What do we mean by law? Most of the time when we use the word law, we use it in the sense of a statute passed by parliament or passed by a state assembly. But there is also the broad area of administrative law, which includes orders, rules, circulars, and it is also important to reduce those, harmonize those, rationalize those. To some extent, that will automatically happen when we begin to rationalize and harmonize the statutes. The final element, which is the element that I've been asked to focus on, because it sounds so very exciting, is the repeal of old laws. Until recently, there were several old laws that existed on the statute books, which were colonial. You might legitimately ask, what harm does an old law do? After all, until recently, I don't know if it has changed recently, but until recently, in London, taxi cabs used to, under the law, have to carry enough hay for the horses. Why? Because the antecedents of that particular piece of legislation goes back to the Hackney Carriages Act, of a vintage when taxi cabs meant carriages drawn by horses. But the point, of course, is that in London, no one is going to harass you as a taxi cab driver for not carrying enough hay in your taxi cab. In Delhi, not very long ago, or before that, there used to be something called the Indian Sarais Act. What does the Indian Sarais Act say, or what did the Indian Sarais Act say? Sarais are these roadside wells. And there were sarai keepers who were supposed to maintain these sarais. So the Sarais Act, late 19th century, said that if you're a sarai keeper, you must give passers-by free drinks of water. Some years ago, a hotel in Delhi was prosecuted for not giving, a five-star hotel in Delhi was prosecuted for not giving passers-by free drinks of water. Eventually, good sense prevailed and the prosecution was dropped, but the fact remains, the point that I was making, the point remains that such old laws can be used to harass people. In Delhi, under the law, if there is an invasion of locusts, the invasion of locusts will be announced by the beating of drums. And every able-bodied person must then be out in the streets helping the government fight off locusts. That's still the law today. I can give you countless examples for different pieces of legislation indicating old laws. I use the word old laws, thereby suggesting that the entire piece of legislation is an old one. It is rarely the case that the entire piece of legislation will be an old one. If the entire legislation is an old one, then the task is relatively easier because you can have a repealing act and repeal all those laws together. Unfortunately, more often than not, it is not the entire act which can be repealed, but there is one particular section of the statute that needs to be repealed. So I'm drawing a difference between repealing the entire statute and repealing or deleting one particular section of a statute. Repealing an entire statute is always easier. If you want to repeal one particular section, you have to systematically sit down with the entire statute, examine it to see which particular section needs to be repealed. To give one example of that, take something like section 377 of the Indian Penal Code. I'm not going to repeal the entire IPC, but I want to repeal one particular section. Alternatively, there are sections in the IPC reflecting when it was enacted, referring to an Asiatic power. Maybe I want to repeal that section. These are examples. I can give you countless examples. As I said earlier, many statutes went back to the 19th century. A little bit like a quiz question, what is the oldest extant statute in India now? After all the repealing that has been mentioned in the course of the introduction. The oldest statute that still exists in the statute books is something that is known as the Bengal Districts Act. The Bengal Districts Act goes back to the year 1836. It is a one 2-sentence statute, and it says that under the Bengal Districts Act of 1836, Bengal is entitled to create as many districts as it wants. We know states are creating districts all the time. They're doing it administratively without necessarily having that particular statute. That statute was, of course, passed in 1836 as part of the Bengal presidency, which is why the Bengal Districts Act not only exists in India, in India and in West Bengal, but also exists in Bangladesh. As was mentioned in the introduction, before that, when we passed the constitution, I think systematically one should have identified old and archaic statutes which should have been repealed. There was a very perfunctory attempt to do this in 1950-51. There was another attempt in 1960-61, but it was still perfunctory. A systematic attempt to get rid of old laws and repeal them in their entirety. The exercise started with LARDS, the project that I mentioned. Then there were several other initiatives, including an initiative emanating from the Prime Minister's office after Narendra Modi became the Prime Minister. I should acknowledge a very remarkable initiative that was undertaken by an organization known as the Center for Civil Society. Before that, there was a Jain Commission after LARDS, which followed LARDS. All of this led to about 1,600 statutes being eliminated through a repealing act in 2015, through repealing acts in 2015 and 2016. Two obvious points to be made. The first obvious point to be made, which you know as lawyers or would-be lawyers, that there are countries, particularly in civil law jurisdictions, where you have a system of desuetude, which means that a statute is enacted for a certain period of time, and beyond that certain period of time, unless a review establishes that the statute needs to be renewed, it dies a natural death. In other words, when a piece of legislation is passed, it is not open-ended. In India, under a common law jurisdiction, and there is also a court judgment to that effect, we cannot have desuetude in the sense that I've just explained it. I mentioned the Bengal Districts Act. If 1,600 odd statutes have been repealed, then why hasn't the Bengal Districts Act been repealed? And the answer is very obvious, that these old pieces of legislation predate the Constitution. But since the Constitution came into being, there is a 7th schedule with a union list, a concurrent list, and a state list. It is the view of the courts that regardless of when the legislation was passed, if a subject is in the state list, the repealing should be done by the state concerned. So roughly around 250 different statutes wait to be repealed because they are pending with states. Which brings me to another issue, which is the role of the Union Law Commission in systematically identifying and repealing old laws, and B, the role of state governments and the role of state law commissions if and when they exist. How many statutes are there in India? It is reasonably easy to count how many statutes there are in India, particularly at the union government level, thanks to India Code. But the state government laws are not yet part of India Code. And the state governments don't do a very good job of listing out all their laws. Now, don't get me wrong, as lawyers, you're familiar with books that are published on state government laws. But those are on selected state government laws. What I have in mind is all laws. Are they available in one place? They aren't really. Let me now quickly turn to an example that you do not know about, because no one has written very much about it. And this is an experiment, not an experiment, this is an exercise that happened in Rajasthan when Vasundhara Raje was the chief minister. Vasundhara Raje, as the chief minister, wanted to get rid of old laws. That's a misstatement. She wanted all the laws in the state of Rajasthan to be exempt. Instead of setting up a state level law commission, she decided to set up a 2-person task force. So I was the chairman of that task force. And the additional secretary, one of the then additional secretaries in Rajasthan was the other member of this task force. It was a 2-person task force. And his name was Rakesh Verma. So I asked Rakesh Verma, the first thing we need to do is let us get a list of all the statutes that exist in the state of Rajasthan. We did that, and we had a list of about 950. So if that is par for the course, you can roughly estimate that on an average, every state government will have about 1,000 statutes. The bulk of which, as you will well imagine, will be in land-related matters. Revenue-related, land revenue-related matters, other land revenue-related matters. Those will be the bulk of the legislation. So we had the names of 1,000 statutes, the titles. Now we wanted the texts, 950 statutes. When we tried getting the texts, we discovered that for 50 statutes, we did not even have the texts. Meaning, we knew that those statutes existed, but we did not have the texts, and there had been no cases. But we wanted to be purists, we wanted to be correct, therefore we wanted all the statutes, all the texts. Do you know where we got the text of these 50 from? All statutes are printed. So we eventually got those texts from the government printing press in Jaipur. And now we had this list of 950. And we began to ask this question. A, do we need this statute? One of the points I want to make before you is when a bill is prepared, when a bill is drafted, it has a statement of objects and reasons. And the statement of objects and reasons today with any bill typically is no longer as good as it used to be once upon a time. The statement of objects and reasons should say very clearly, why do we need this piece of legislation? What are the benefits from having this piece of legislation? What are the costs associated with enacting this particular piece of legislation? And I don't mean only financial costs. That kind of systematic exercise is not really done, a cost-benefit exercise of legislation. Since it is not done, quite often we have unnecessary legislation. So A, the first question we asked, do we need this statute? B, assuming we need this statute, shouldn't we rationalize and harmonize? And C, once we have done part A and part B, repeal and rationalize and harmonize and unify, shouldn't we apply the same logic to the administrative law, the rules, orders, and regulations, and put everything up on the website so that it's freely available? One point that I want to mention, which is very important, but it is not sufficiently appreciated by people who are outside the government system. Every statute is administered by a department. And the department has a sense of ownership over that. So the department is very reluctant to let go. This statute, you're going to repeal it, you're getting rid of my property. And this is extremely, extremely strong, and it requires intervention at the highest level, the chief minister for a state government, the prime minister for union government, for this particular exercise to be done. As a result of all of this, we reduced the number of statutes in Rajasthan from 950 to 200. From 950 to 200, it was done through repealing acts. But there is one last point I want to mention, and again, this is sometimes not adequately appreciated. Quite often when we are talking about repealing legislation, we are talking about an ideological position on what the state should do and what the state should not do. What do I mean by that? Take an example from Rajasthan, the Boating Regulation Act. Should the government be in the business of regulating boats? Or take the Indian Aircraft Act, which is an Indian government level legislation. Indian Aircraft Act of 1934. As the name suggests, it gives the government the power to regulate aircraft. But the definition of aircraft, if you look at it, is not only planes, it is also kites, not the birds, but the kites you fly. Should the government be regulating those? So there is an ideological position about what the state should do, state as in government should do, and what should not do. Had we been able to generate the political economy to reduce the role of the government, the number of statutes in Rajasthan would have dropped from 200 to 100. In very, very broad and sketchy terms, I have given you some examples of what it means to engage in law reform and what it means to specifically eliminate and repeal old statutes. Often the work gets done because people outside the government are interested, like the Center for Civil Society, or the work gets done because the pressure is exercised, the countervailing pressure is exercised by members of civil society, people like you. Thank you very much.
Thank you, sir, for giving us some wonderful insights into the project and the effort that has gone into the repeal of laws that have turned obsolete, and many a times we know that these laws were used to harass people. Without any further ado, I would like to start with the question and answer session. So students can start posting their questions in the chat box. In the meanwhile, I as the moderator wanted to ask a question. So you, in the beginning of the talk on law reform, you also talked about the increasing judicial pendency, that nearly 4 crore cases are pending in the courts in India. Now it has been found that in many of these cases, government is the litigant on both the sides of the matter. One department of the government is a litigant on one side and the other department is a litigant on the other side. So, separate from the regular judicial process, is there any way these cases can be first dismissed on a priority basis?
Let me ask you something. In what percentage of cases do you think the government is litigating? On both sides?
On both sides, I would say the ratio would be, the percentage would be small, but it is a litigant in more than 50% of the cases. One side, the government is a litigant.
There's a reason why I asked you. There's a reason why I asked you. In 1994, Madhav Menon and I edited a book called Aspects of Law Reform in India. That book had a paper which was based only on a sample survey done in Karnataka. That to Karnataka High Court. And for Karnataka High Court, that particular paper found, that sample found, that in 60% of cases, the government of civil cases, if it is a criminal case, obviously the government will be litigating on one side. But it found that in 60% of the cases, the government was litigating, sometimes on both sides. And a large number of this litigation was in the nature of appeals, which often failed. I wanted to stress this because that 60% figure keeps getting quoted by people without it being recognized that it applies only to Karnataka High Court and not across the board. Across the board, the figure is a bit lower than 45% now. So roughly 45% of civil cases, the government is litigating, not on both sides, on one side. There has been an exercise done by union government. You are probably not aware of it because it has not been disseminated enough. It is called LIMS. LIMS is a database. You will find LIMS on the Ministry of Justice's website. You will not be able to access the data because the data is not meant for research. The data is meant for improving policy, but you will be able to get a sense of what LIMS is about. What LIMS does is to collect the data on all union government, not state government, union government ministries and departments who are litigating on civil matters, not criminal matters. On civil matters, let's put together a database which tells us which ministry, which department is litigating and what is the issue. As a result of this LIMS exercise, which mind you is not very old, it started about 4 years ago, one has been able to cut down on unnecessary appeals, particularly on service matters. A large chunk of union government cases are on service matters. One has been able to cut down on appeals. And of course, one has been able to cut down on 2 government departments. I said government, but I really mean including PSUs also, litigating against each other. What one needs to do is to replicate something like this at the level of the states. It has not yet been done to the best of my knowledge at the level of the states.
Thank you, sir. We have Arya with us who wants to ask a question. Arya, if you could turn on your mic and you can ask.
A very good evening, sir. I'm Arya. I'm a second year student here. Sir, I wanted to get your views on the plain language movement in India, which is basically drafting legal documents in a manner which is say free of most legal jargon and is comprehensible even to the common man who hasn't read law as we do.
I'm glad you asked this question, because this is something I wanted to mention but check myself because of the time constraint. Is that when we did this law reform exercise for Rajasthan government, one conscious attempt was to draft the law in plain English. Since we are studying law, the model, well, maybe I shouldn't say that. Well, since I've started to say it, let me say that. The model, in a sense, was Lord Denning's judgments. So no sentence should be more than 20 words. No unnecessary Latin words. And one of the fights I kept having was with the expression, and this is independent of law reform. One of the fights I keep having is with the expression inter alia. I'm not talking about law. Every government file will generally have this expression inter alia. And I have no idea why it should be included. So I'm glad you asked this question. And it is a very important issue of using plain language. And plain language, not only for drafting of legislation, but also I happen to think for judgments. And I personally think that the judgments would become a lot simpler if judges wrote the judgments as opposed to dictating them. You will notice that if you're writing something down, or typing it yourself on the computer, you tend to use simpler language with clear ends to the sentences, with punctuation marks, whereas if you're dictating it, it tends to be completely different. And I think sometimes some of the judgments sound so long-winded is because judges actually dictate. So I completely agree with you, but it is also not very easy to find very good skill sets in terms of people who can draft legislation and can draft it with that plain English language point of view in mind. And remember, when we are saying all this, it is not only plain language in English, because the statutes and sometimes the rules, orders, regulations will also have to be translated into other languages. So the plain language movement applies equally there too.
Thank you, sir. We have a question from Badita Agarwal. Considering that many of these laws are repealed without adequate discussion in the parliament, how important do you think is the role of the opposition when it comes to repealing of such old laws by the parliament?
I think it is a more important issue for enacting new legislation. Not repeal. The outright repeal, not repealing a section, that's different, because that will require an amendment. So effectively, functionally, it's almost like passing a new piece of legislation. If it is outright repeal, the cases for outright repeal are fairly obvious, so it will not be a contentious issue. The contentious issues will only be when it is a repeal of a particular section. And I think we are talking about the functioning of Parliament and the functioning of legislative assemblies. At a general level, there is some scrutiny now of Parliament. I don't think there is enough scrutiny of state-level legislative assemblies. PRS, an organization that you are familiar with, has probably for the first time ever done an annual report on the functioning of state assemblies. It happened recently, right in the midst of the COVID pandemic, so it was an unfair point in time in which to judge. Nonetheless, it illustrates the limited amount of time that state assemblies devote discussing any particular piece of legislation. Typically new legislation, but the argument would also apply to repeal. In Parliament, I think what has happened is the functioning of the committee system. The committee system functions quite well with the understandable time lags. And often the tendency is, if the committee is examining a piece of legislation in detail, then what is the necessity, regardless of my political coloring, what is the necessity for me to examine the legislation afresh when the committee has gone into it in great detail? So in a perverse kind of sense, the efficient functioning of the committees has meant that the average MP does not spend that much of time discussing a bill in open parliament, although it is also the case that all MPs, almost all MPs, are members of one or the other of the committees.
Thank you, sir. There's another question from Arya. Sir, do you think that there is a need to relook and reconsider the 7th schedule and the lists?
The obvious answer is yes. The obvious answer is yes. Personally, I think, oh no, before that, let me add a remark. I personally think that we need to take a look at several elements of the Constitution. As students of law, you no doubt know, but it is not generally known that the Constitution is largely inherited from the Government of India Act of 1935. And the Government of India Act of 1935 built on the Government of India Act of 1919. So there is a clear case for examining the union-state relations, which are a legacy of the dealings with the provinces of the time. The 7th schedule is one part of it. Now, so far as the 7th schedule is concerned, my personal view is that there should be a union list, there should be a state list, and there should be a local body list with no concurrent list. I think the concurrent list is no longer necessary. I also think a local body list is necessary because the delegation of funds, functions, and functionaries to local government is left essentially, notwithstanding the 73rd and the 74th constitutional amendments, is left to the discretion of the state government. Economists will tell you that governance-wise, India is excessively centralized. It was centralized under the British for land revenue and other considerations. Immediately after 47, it was centralized for other reasons. And economists, therefore, have often said governance must be decentralized. So far as the 7th schedule is concerned, I would like to see a pruned union list, also a pruned state list, and a longish local body list. And remember that most of the public goods and services we want delivered as citizens are actually delivered by local bodies, which is why I said a longish local government list, local body list. They can be principles as to how one should go about looking at the 7th schedule. And in case you are not familiar with this, do take a look at a paper that Vidhi, I'm not sure whether it was Vidhi or Daksh, I think it was Vidhi, a paper that Vidhi did on the 7th schedule, taking a relook at the 7th schedule. It is there on the Vidhi website. You don't have to agree with those principles, but at least it logically went about setting out some principles which should determine which entry should be where in the union list, state list, or some other list.
Thank you, sir. There's another question regarding the constitution from Priyadarshini Dutt. Do you think that in the foreseeable future, there's a possibility of reinstatement of the right to property as a fundamental right under the constitution?
You are the lawyers. Amending the constitution is always very difficult. B, although personally I would like the right to property to be restored as a fundamental right, I do not see any pressures building up for that. C, and I'm sort of provoking you. C, we get into issues of the basic structure of the constitution. And I'm asking the following question, which is meant to be a rhetorical question because the Supreme Court has already decided on this. A constitution is supposed to reflect the aspirations of the people. The aspirations of the people change over time. So the constitution, to borrow an expression from Granville Austin, should be dynamic. How are the aspirations of the people reflected? The aspirations of the people are reflected through parliament or through state assemblies. However, we have a decision that the basic structure of the constitution cannot be changed. Who decided and how was it decided? In that particular judgment, had one judge ruled in the other direction, had one judge taken a position in the other direction, the ruling would have been completely different. But we are now stuck with this proposition that the basic structure of the constitution cannot be changed regardless of what the people of the country want in the future. So instead of becoming dynamic, the constitution has become static and frozen in stone. The next question that arises is, who determines what the basic structure of the constitution is? It will be left to courts. As a citizen, not as a lawyer or a judge, as a citizen, I find this somewhat strange, that constitutional amendments which should reflect the will of the people will be cast in this cage that has been created for us because of the basic structure doctrine.
Thank you, sir. Pratyush wants to ask a question. So if Pratyush is here, he can turn on his mic and ask.
Good evening, sir. Sir, am I audible?
Yes.
Thank you, sir. Sir, it was really an insightful session, and I'm sorry. Yes, sir. So I really I'm sorry, sir. I'm a bit nervous right now. So
You
you
shouldn't be
talked about,
nervous. You should be
uh,
nervous in what?
yes, sir. So you talked about reforms a lot in during this session, and a recent bill comes to my mind, which was the Tribunal Reforms Bill. So, sir, this bill actually was meant to rationalize service of the judges of these tribunals, but actually it was subject to substantial litigation and has now rendered surmounting vacancies in the tribunals. Obviously, the government did it with the best of its intentions, but right now with the prevailing state of affairs and every year we see a new amendment with respect to this, it seems that we were better off without the reforms. So how can we avoid such instances?
Uh, I can't really comment on that. The reason I cannot comment on that is, look, on basic principles, the tribunals should be similar with similar powers. We should rationalize across tribunals, and we should rationalize across the powers of those tribunals, and we should also rationalize the process of appointments, and if the need arises, removal of the chairperson and members of tribunals. That's first principles, basic principles. There can be specialized tribunals where the chairperson and the members may or may not be from the judiciary. This is on first principle basis because it depends on the nature of the tribunal. But as you said in your question, this matter is sub judice on that very particular issue. And yes, we therefore have this problem. And yes, that is indeed the case. And that is the reason why many of the positions cannot be filled up. I have no idea when this is going to be sorted out. So I shall stop there.
Sir, how many more questions can you take?
How many more? Maybe two.
All right. So we have a question from Aditi. He's asking about what is your opinion on limiting the Supreme Court to a strictly constitutional court that hears only constitutional cases, and if we can set up separate appellate courts, let's say in four metropolitan cities, to hear appellate cases from the high courts.
I completely agree with the idea, and again, I don't know whether you've read it or not. There is another very good report by Vidhi or Daksh, or maybe both, suggesting something very, very similar. But in addition to this, there are two additional points I want to make. One, I think there is a clear case for reducing the number of appeals. The question was asked about the Supreme Court, so I'm making the point about the Supreme Court, but I think it's true in general. We should have far fewer appeals. I think there is also a case for handing over many of the management issues in courts to people who have skills for that particular purpose. An academic is not always the best registrar for a law school. So you appoint a registrar who possesses administrative skills and you leave the faculty member free to teach. The same logic applies to courts. So in addition to what you have said, and I agree with that, I think there is a case for professional management of the court system.
Thank you, sir. We have one last question Okay, Saurabh is asking about your comments on the recent amendment to the retrospective tax law.
Well, no, there's no comment that I can make really. It should have happened a long time ago. I don't think this provision was at all warranted. The reason it took such a long time, apart from the processes within Parliament, is because there was litigation. And thankfully, it's out of the way now. There are some settlement issues which will be done. But the bottom line is, I do not think this provision, it's bad law, I think, and I don't think this provision should have been introduced in the first place.
Thank you, sir. With this, we come to the end of the question-answer session for today's session. I would now like to call upon Krishna Tiwari to deliver a vote of thanks.
A very good evening, sir. On behalf of the informal discussion group, NUJS, I, Krishna Tiwari, would like to express my sincere gratitude to you. We are extremely honored that you graced us with your presence today. It is a privilege for us to have interacted with you, and I'm sure each and every one of us is taking away something valuable from this immensely insightful session. I would like to thank you for enlightening everybody present here on the repeal of archaic and observed laws and share your valuable experience in the area. I would also like to thank the members of the committee who contributed in making this session a success. I'd like to thank the members of the faculty and other attendees for their graceful presence and bringing up such wonderful and relevant questions. Thank you very much.
Okay, thank you. Namaste.
Thank you so much.
Thank you so much, sir.